Welcome to week 6 of evidence. This week we will move on to the topic of writings. We'll cover the cases from your casebook in pages 669 to 696. The first case that we covered is Myers v. United States. This is a United States Court of Appeals case from 1948. As background, we have a defendant who was accused of encouraging someone to lie under oath. The prosecution then introduced oral testimony from a witness about what that person had said under oath. The government also introduced the transcript of that person's testimony into evidence. At issue was, does the best evidence rule apply here, requiring that the stenographic transcript of that person's testimony be introduced rather than the oral testimony about what was said under oath. The court held here that the best evidence rule did not apply, and it was not an error for the government to admit that witness's oral testimony, despite the existence of the transcript. And this was because the government was not attempting to actually prove the contents of the transcript. They had someone willing to testify about what was said under oath. And so that oral testimony about what the person said was not actually proof of the contents of the writing, which is when the best evidence rule becomes implicated. For example, here the transcript could be different than what was actually said under oath. And so the person's oral testimony about what was said under oath was sufficient. The next case is People v. Inscat. This is a Superior Court for LA County case from 1971. As background, we have a defendant who was charged with showing an obscene film. The plaintiff offered oral testimony from the police officers about what they saw when they viewed the film. They also admitted pictures about what they saw when they came to the scene. The defendant objected on best evidence grounds, but the objection was overruled and the defendant was ultimately convicted. At issue is, does the best evidence rule apply to the offered evidence of the police officer's testimony, and does it apply to movies? Meaning, does that count as a writing under the best evidence rule? The court held that it was reversible error to allow the oral testimony of the officers. They held that the best evidence rule did apply, and the prosecution needed to have presented the original film, or a reason why it could not have been produced. The court also held that the pictures the police officer took of the film were inadmissible without an excuse for why the original, the film, was not produced. Our next case is United States v. Diaz-Lopez. This is a United States Court of Appeals for the Ninth Circuit case from 2010. As background, we have a defendant who was a Mexican citizen accused of being a removed alien in the U.S. without permission to return. A Border Patrol agent testified that he had performed a search of the relevant government database and found no record of defendant having filed the form necessary for readmission. At issue was whether or not the Border Patrol agent's testimony violated the best evidence rule. The court here rejected the defendant's argument that the Border Patrol's oral testimony violated the best evidence rule because the original printout of the database search was not produced. The court noted that the best evidence rule does not apply to testimony that records have been examined and found not to contain a reference to a particular matter. So in this case, again, the best evidence rule was not implicated. Our next case is United States v. Dawkins. This is a United States Court of Appeals case for the Fifth Circuit from 1993. As background, we have a defendant who was charged with illegal possession of a firearm by a convicted felon, as well as knowingly making false statements during the purchase of a firearm. The prosecution sought to admit records, including a fingerprint card, that purported to come from the Denver Police Department to prove that the defendant was a convicted felon. At issue was, did the prosecution properly authenticate the records from the Denver Police Department? The court held that the records, including the fingerprint card, were not properly authenticated. However, the court held that it was harmless error for the judge to still receive them. Next case is United States v. Hampton. This is United States Court of Appeals for the Seventh Circuit case from 2006. Here the defendant was a serial bank robber. An element of the federal bank robbery crime that defendant was charged with was that the bank needed to be federally insured at the time of the robberies. The defense counsel here refused to stipulate that the bank was federally insured, even though it was. And so the plaintiff produced copies of the certificates that the bank was federally insured. At issue was whether or not the copies of these certificates showing that the bank was federally insured, whether they were self-authenticating as sealed documents. The court held that no, just because a document is under seal and self-authenticating does not mean a copy of that document is also self-authenticating. Nonetheless, the court held that the copies were admissible as evidence, but held that the prosecution's proof was sloppy. It suggested that in the future, the prosecution should get an affidavit from the FDIC or deposition from an FDIC officer confirming that the banks were insured. The next case is First State Bank of Denton versus Maryland Casualty Company. This is United States Court of Appeals for the Fifth Circuit case from 1990. As background, the plaintiff, a bank and executor of J.T. Mills's will, sued the defendant to recover for fire insurance. The house that was Mills's previous home and was currently unoccupied had caught fire in the middle of the night. The defendant alleged that Mills had set the fire himself. As evidence that Mills had set the fire, the defendant sought to show that Mills was not at his new house at the time of the fire, meaning that he could have been out setting the fire. The plaintiff appealed and claimed that the trial judge erred in admitting a phone conversation between a police dispatcher and an unknown man at Mills's home who had answered the phone during the time of the fire and claimed that Mills was not there. At issue is whether the phone conversation was properly authenticated so as to be admissible at trial. The court held that it was, that evidence of the call was properly authenticated. The dispatcher had testified that she had dialed the correct number and that the person answering the phone said that he was at the Mills's residence. That person then also said that Mills was not home. The court felt this was enough to authenticate that the call was actually made to Mills's home. We'll have one casebook hypo on page 687 that we will discuss as a class. Our last case is Griffin v. State. This is a Court of Appeals of Maryland case from 2011. As background, the defendant was charged with a homicide. The state offered evidence of what it claimed to be the defendant's girlfriend's MySpace profile. The profile had a threat against a prosecution's witness. A police sergeant testified that he had found the profile by going to MySpace. The prosecution then argued that the page had a photo, apparently showing the defendant and his girlfriend together, along with accurate personal information like their date of birth and names. It had the threat itself to that prosecution witness and also references the defendant by a nickname, and that this was sufficient to authenticate the MySpace page. At issue was whether the MySpace page was properly authenticated and admitted as evidence against the defendant. A majority of the court held that the prosecution did not properly authenticate the MySpace page. In its analysis, the court listed 3 alternative methods that the prosecution could have done to authenticate properly. The court said that the prosecution could have asked the girlfriend herself whether or not it was her MySpace page and had her testify to that fact. They could have performed a search of the girlfriend's computer, and they also could have tried to gain evidence from MySpace directly. It's unclear after reading this opinion whether the second two options here would have actually been feasible, but nonetheless, these were the suggestions from the court.